Thank you, Mr. Chair. In June 2023, the FTC quietly issued a rule effectively diminishing the role of its administrative law judge, or ALJ. Under the new process, the ALJ will no longer render an, quote, initial decision, unquote, that would become the agency's decision, but instead issue a recommended decision that would be revised by the same FTC commissioners who brought a complaint in the first place. Mr. Chenoweth, this looks on the surface as if Chair Khan is unhappy with her track record in front of the ALJ and is trying to further stack the deck against merging parties. What are your thoughts on that comment?
I think you're right, Congressman Fitzgerald. The fact that the FTC is trying to diminish the role of the ALJ in this way is troubling. It does suggest that they're looking for an outcome determinative sort of result from the ALJ rather than asking the ALJ to exercise independent judgment. I think it just underscores what we were saying in some of our opening statements about the fact that these ALJs are not independent. They're under the thumb of the agencies at any point in time. They can be intimidated. They can be demoted in the way that has happened at the FTC. And that's why we need these sorts of cases to be in front of real judges in real federal courts.
So further adding to this narrative that Chair Khan has been stacking the deck, just last week they announced that the FTC had hired Jay Himes to serve as one of the agency's ALJs. And Mr. Himes has previously represented Open Markets Institute, in front of the FTC, the very same organization in which Chair Khan's mentor, Barry Lynn, founded and which Chair Khan herself served as legal director. So again, let me ask you kind of a follow-up question. So the FTC used to have this neutral ALJs with a track record of careful deliberation and kind of this impartial view of antitrust law. Should businesses, or how should they anticipate, or should businesses be worried how this is perceived and the bias involved in it?
Well, I think there's tremendous bias. The only thing I would take issue with that you said, Congressman Fitzgerald, is that the old ALJ is completely unbiased, because if you look at the FTC's track record in front of its own ALJ, it won something like 24 out of 25 times in a row. And it was only the one time when the ALJ didn't rule in favor of the agency that the agency then turned around and decided to hire a new ALJ and demote the old one. So, I mean, it just sort of tells you everything you need to know about how this process works in the real world.
Yeah, I probably agree with your comment. It seems to me the biggest problem is the FTC getting kind of two bites at the apple when it comes to challenging mergers. They can seek a preliminary injunction in federal court, and if they lose, can conduct a full administrative trial before ALJ. Court records from the recent case of Accent Enterprises versus the FTC revealed that over 25 years, the FTC has not lost a single case that went through their own administrative process. And you compare that with the agency's success rate in federal court, which is, somewhere around 50% probably. So perhaps even worse, they don't even have to listen to the ALJs. They can simply overrule the decision, and they do nearly unanimously. And then previous testimony before the committee shows that the ALJ has overruled the FTC only 5 times in the last 25 years. Should Congress continue to allow the FTC to take, as I described it, 2 bites at the apple? Mr. Alt, do you have, maybe you have a comment on that?
Obviously, I think that's problematic, and this is something that we see with multiple different agencies where they really have a choice as to how to proceed with actions against potential defendants, with a general lack of transparency as to whether or not they begin with an in-house proceeding or go into federal court. This ends up being extraordinarily problematic. Going to your previous question with regard to the lack of bias or the specialization of the particular ALJs who are giving them one of the bites at this apple. One, if you actually take a look at these ALJs, frequently they actually don't have peculiar specialization in the areas. Frequently, they may be brought in from another agency where they've got some previous adjudicative experience, but not necessarily anything within the particular agency in question. That ends up being problematic. But I think it really goes back to what we talked about at the beginning about the protections that are put in place in the Constitution for the exercise of judicial power. One of them ends up being the advice and consent of the Senate. And so when you have something like the question you had about the lack of bias on the part of the ALJ, those things can be explored by subjecting a nomination to the advice and consent process, which the Senate Judiciary Committee is fully capable of doing. However, on something like, with regard to many of these ALJs and non-ALJ positions, they are not subjected to that kind of review.
Thank you, Chair. Mr. Chair, I'll yield back. Thank you.